Welcome to today's program, Legal Ethics, the ChatGPT Lawyer's Sanctions Case. My name is Zach McGee. I'm a Senior Vice President, Business Affairs for Sony Pictures Entertainment. Prior to joining Sony Pictures, I was an in-house lawyer at NBC Universal, and before that, I was a lawyer at Davis Polk. I've been writing and speaking on legal education topics for the past 20 years, including having taught a course on legal ethics at Pepperdine Law School. As you might expect, I'm speaking today solely on behalf of myself, and my views don't reflect those of my current or any former employers or institutions with which I've been affiliated. Our topic today is the now infamous case of the two New York lawyers, Stephen Alan Schwartz and Peter P. Loduca, and their law firm, Levidow, and Oberman, P.C., who were sanctioned under Rule 11 of the Federal Rules of Civil Procedure by Senior Judge P. Kevin Castell of the United States District Court for the Southern District of New York for submitting an affirmation in response to a motion to dismiss that cited 6 federal court decisions that did not, in fact, exist. Mr. Schwartz, who took the lead in preparing the affirmation and in responding to the court's inquiries once it became suspicious that the cases might be fake, had asked the generative AI chatbot, known as ChatGPT, to provide him with case law support for the argument he was making, and ChatGPT simply made up the cases. Each case had party names, a docket number, a reporter citation, and text that purported to be the opinion of the court, but they were fake. Mr. Schwartz didn't do anything to confirm that the cases were real before he submitted them to the court, basically claiming that he thought the results from ChatGPT were the same as results you would find by researching the same issue on Westlaw or Lexis. Mr. Schwartz and Mr. Loduca, who was counsel of record because Mr. Schwartz was not admitted to practice in the United States District Court for the Southern District of New York, also didn't do themselves any favors when they failed to tell the court the truth, the whole truth, and nothing but the truth when they were questioned about their conduct. To tell you what you probably already know, if you have heard of this case before now, Judge Castell ultimately sanctioned Messrs. Schwartz and Loduca and the Levidow firm under Rule 11 and ordered them, jointly and severally, to pay a fine of $5,000. Judge Castell also ordered the respondents to send their client a copy of the court's sanctions order and to send letters individually addressed to each of the judges falsely identified as authors of the fake cases. Needless to say, ouch. We are going to go through the facts of this case and Judge Castell's opinion and order on sanctions in detail, because all of it is fascinating, and it would appear to be a case of first impression. We'll also talk about the legal ethics rules that the ChatGPT lawyers likely violated as a result of their conduct. As of this recording, there is no public record of discipline against either Messrs. Schwartz or Loduca arising from this case, but I think it's safe to say that the New York State Bar is likely taking a careful look at that. By the end of our time together today, you'll see why the ChatGPT lawyer's sanctions case is a cautionary tale for any lawyer who might be tempted to use ChatGPT or other generative AI tools to assist them with legal research or legal drafting. Before we can dive into the facts of the case, I need to provide some background on the ChatGPT tool in particular, and on generative AI technology in general, because I suspect that many lawyers have heard of recent developments in these areas, but likely do not know exactly what we're talking about. So, what is artificial intelligence and generative AI? How do we get to a place where lawyers and anyone else can type questions into a generative AI chatbot like ChatGPT and receive what appears to be a thoughtful answer? Let's start with artificial intelligence, known as AI. AI refers to the simulation of human intelligence in machines that are programmed to perform tasks that typically require human intelligence. It is a broad field of study that encompasses various subfields such as machine learning, natural language processing, computer vision, robotics, and more. AI systems aim to mimic cognitive functions associated with human intelligence, including perception, reasoning, learning, problem solving, and decision making. These systems are designed to analyze and interpret vast amounts of data, identify patterns, and make predictions or take actions based on the analysis. There are two primary types of AI. Number one, narrow AI, also known as weak AI. Narrow AI is designed to perform specific tasks within a limited domain. Examples include virtual assistants like Siri and Alexa, recommendation algorithms used by streaming services, and fraud detection systems in banking. Number two, general AI. General AI, also referred to as strong AI or artificial general intelligence, AGI, refers to AI systems that possess human-level intelligence and can understand, learn, and apply knowledge across various domains. General AI aims to exhibit the same level of intelligence and versatility as humans. Key techniques and approaches used in AI development include: number one, machine learning. Machine learning algorithms enable AI systems to learn patterns and make predictions or decisions based on data without being explicitly programmed. This approach involves training models on large data sets and iteratively refining them to improve performance. Two, deep learning. Deep learning is a subset of machine learning that uses artificial neural networks inspired by the structure and function of the human brain. Deep learning models, known as artificial neural networks, are capable of learning hierarchical representations of data, enabling them to process complex information and perform tasks like image recognition or natural language processing. 3. Natural language processing. Natural language processing focuses on enabling computers to understand, interpret, and generate human language. It involves tasks such as speech recognition, language translation, sentiment analysis, and chatbots. 4. Computer vision. Computer vision involves teaching machines to understand and interpret visual data, such as images and videos. It enables AI systems to perform tasks like object recognition, facial recognition, and image captioning. AI has applications in various fields, including healthcare, finance, transportation, cybersecurity, entertainment, and law, among others. Its potential impact on society, ethics, and the future of work has prompted ongoing discussions and debates. That's AI in general, but what is generative AI? Generative AI refers to a subset of artificial intelligence that focuses on creating or generating new content, such as images, music, text, or even entire simulations, based on patterns and examples from existing data. Unlike other AI approaches that primarily aim to analyze or classify existing data, generative AI systems aim to produce new and original content. Generative AI utilizes techniques like generative models, which are algorithms designed to learn the underlying patterns and structures of a given dataset. These models can then generate new data that resembles the patterns observed in the training data. Here are a few examples of generative AI applications. Number one, image generation. Generative models can learn from large datasets of images and generate new images that resemble the patterns and features present in the training data. This has applications in areas like art, design, and computer graphics. 2. Text generation. Generative AI models can be trained on vast amounts of text data, such as books, articles, or conversations, and generate new text that follows similar patterns. This is utilized in tasks like language generation, dialogue systems, and content creation. Number 3, music composition. By analyzing existing music compositions, generative AI can learn patterns and create new pieces of music in various genres or styles. It has applications in music production, composition assistance, and generating background music for media. Number 4, video synthesis. Generative AI models can learn from videos and generate new video sequences that resemble the training data. This can be used for tasks like video prediction, video completion, or generating synthetic training data for computer vision algorithms. Generative AI holds great potential for creative applications, content creation, and assisting human designers or artists. However, it also raises ethical considerations, such as issues related to ownership of generated content, potential biases present in training data, and the responsible use of AI-generated outputs. It's important to note that while generative AI can produce impressive and realistic results, it is still an ongoing area of research and development. The generated content may not always be perfect or indistinguishable from human-created content, and the quality and ethical implications of generative AI outputs should be carefully considered in practical applications. You might be tempted to ask, why is AI having a moment right now? Because it's been around in one form or another for decades, right? Yes, AI was pioneered in the 1960s by Joseph Weizenbaum at MIT, who created the first chatbot, Eliza. Eliza was designed to simulate a psychotherapist and was based on a simple, rule-based system that allowed it to generate responses that were similar to those of a human therapist. Chatbot development continued in the decades that followed, producing more sophisticated chatbots that were able to hold more complex conversations. In the 2000s, chatbot development took a major leap forward with the development of large language models, LLMs. LLMs are trained on massive datasets of text and code, which allows them to generate more realistic and human-like text. Bard, the generative AI chatbot from Google, and ChatGPT are two of the most advanced chatbots that have been developed using LLMs. The next major milestone occurred on November 20th, 2022, when OpenAI released ChatGPT-3. ChatGPT-3 is one of the largest language models ever created, with 175 billion parameters, and is trained on a vast amount of text data. As a result, ChatGPT-3 can generate human-like text in a wide range of contexts and has been used in a variety of applications, including language translation, summarization, and question answering. The release of ChatGPT-3 and other advanced language models has opened up new possibilities for their use in a variety of fields, including the legal profession. That is why generative AI is having its moment right now. Lest you think this is all hype, like virtual reality, the metaverse, and blockchain that were all supposed to change the game, but so far haven't. There are some very smart people saying that generative AI is different and that we should believe the hype. Sundar Pichai, Google's CEO, recently said, quote, AI is one of the most important things humanity is working on. It is more profound than, I don't know, electricity or fire, end quote. That's a bold statement from a very smart guy. So I think we should pay attention to this new tool. But we also need to temper our enthusiasm by listening to another very smart guy, OpenAI's CEO Sam Altman, whose company created ChatGPT and who emphasized shortly after its release that it would be, quote, a mistake, end quote, to rely on ChatGPT, quote, for anything important right now, end quote. So, how do chatbots like ChatGPT actually do what they do? There are highly technical explanations, but for lay people, that includes most lawyers. Let me offer a few common sense analogies. ChatGPT works by predicting the next word or token based on a sequence of words in the prompt. One way to think of this is that it is like autocomplete on steroids. You've no doubt seen autocomplete work when you're composing emails or texts to predict the ending of words or phrases that you start. ChatGPT takes this to a whole other level by predicting the answer to questions that you ask, which seems to the user like the chatbot is answering the question. ChatGPT is able to do this by using neural networks that are loosely based on the architecture of our brains, but in this case, each neuron is connected to many other neurons, 175 billion connections in GPT-3. ChatGPT models are then trained to predict the next word by calibrating the strength of the connections between neurons to minimize prediction errors, much like calibrating coefficients in a regression. I hope that gives you some sense of how ChatGPT does what it does without causing your eyes to roll back in your head. Another absolutely key takeaway: you must never forget that chatbots are not humans and they have no concept of truth, no values, and no reflection. Because ChatGPT has no concept of truth, if it provides you with an answer that isn't accurate, ChatGPT has no way to distinguish it from an accurate one. ChatGPT served up the answer it did because your prompt correlated best with that answer, even if the answer turned out to be wrong. As two commentators who took ChatGPT for a test drive aptly put it, quote, ChatGPT-3 is currently the opposite of a lawyer. ChatGPT delivers wrong answers with a high degree of confidence. Good lawyers deliver well-researched information with a substantially moderated level of confidence, couching answers with maybe and probably and it depends. Lawyers are highly self-conscious about the consequences of being wrong, and even more aware of the potential disaster that giving a wrong answer confidently could have on their case, their client, and their law license. ChatGPT, meanwhile, does not know or care if it is wrong, end quote. At this point, you already know far more about AI, generative AI, and ChatGPT than Mr. Schwartz knew before he used it to research cases for the affirmation he filed that got him into hot water with Judge Castile. That was his biggest sin, using and relying on a new technology that he didn't understand, and no lawyer should ever do that. We'll talk about our duties under the legal ethics rules in a bit, but it's just a basic point that when you're a lawyer representing a client, you have to know what you're doing, and if you don't know something that could be important, you need to find out the answer before acting. If Mr. Schwartz had done any checking whatsoever, even something as simple as typing into a Google search box, "Is ChatGPT reliable?" he very likely would have learned that a major problem with ChatGPT and other generative AI tools is their accuracy, or more accurately, their lack of accuracy. So, is ChatGPT accurate? The short answer is that the content created by generative AI very well might be accurate, but you can't rely on its accuracy without checking it for yourself. In another presentation I've done on the legal ethics issues raised by ChatGPT, I offered what I think is a good analogy. The content ChatGPT creates is like a memo of law written by a summer associate at a law firm. Let's assume the memo is well written. Most law students are good writers. There are no major spelling or punctuation errors, and the sentences are complete and they make sense grammatically. So, there are no obvious red flags that suggest the writer didn't know what he or she is doing. This is very much like the content produced by ChatGPT. It is polished and there are generally no obvious red flags in terms of spelling, punctuation, or grammatical errors. But when you're reading a memo of law, what you really need to know is, does the memo accurately set forth the state of the law on the topic of the memo? What real lawyers do with memos of law written by summer associates is that they read them and then they do their own research to see if the summer associate got it right or wrong. If the memo says that a case stands for XYZ proposition of law, summer associates can often get that wrong, and very often 180 degrees of wrong, because they miss the whole point of the case. This is particularly true when you are applying a legal rule to the facts of your case, i.e. performing legal analysis. If you miss a key distinction that a case is making, for example, that the driver of a car involved in an accident was an employee of the defendant acting within the scope of his or her employment at the time of the incident, you'll come up with the wrong answer when you apply the legal rule to the facts of your case. ChatGPT has the same flaws as an inexperienced and sometimes careless summer associate, and so its work product must be checked and verified exactly the same way. That is part of the problem with ChatGPT content. It seems plausible. Just like a memo of law from a summer associate seems plausible, and you may want to believe that it's right because it looks polished and cogent. But it could be completely wrong. What lawyers don't do, with the exception of the lawyers in the ChatGPT sanctions case, is take a memo of law written by a summer associate and file it with the court. Now, summer associates typically don't make up fake cases, at least we hope they don't. But my analogy still holds because ChatGPT made each of the fake cases look plausible. Each case had party names, a docket number, a reporter citation, and text that purported to be the opinion of the court, but they were fake. If you think about content generated by ChatGPT as that summer associate memo of law, you'll be in the right frame of mind for how you should approach that content. Let me illustrate the point with another example. I asked ChatGPT to, quote, tell me about Abraham Lincoln's childhood and early political career, end quote. And here is what it produced. Abraham Lincoln, one of the most renowned American presidents, had a humble childhood and embarked on a notable political career. Abraham Lincoln was born on February 12, 1809, in a log cabin in Hardin County, Kentucky, which is now part of LaRue County. He was the second child of Thomas Lincoln and Nancy Hanks Lincoln. At the age of 7, Lincoln and his family moved to Indiana, settling in Spencer County. Lincoln's childhood was marked by poverty, hard work, and a thirst for education. Although Lincoln received limited formal education, he was an avid reader and self-learner. He borrowed books and educated himself on various subjects, including history, politics, law, and literature. This love for learning and intellectual curiosity would play a significant role in his future endeavors. Lincoln's political career began in the 1830s when he became involved in local politics in Illinois. He ran for the Illinois General Assembly in 1832, but was unsuccessful. However, he won a seat in the state legislature in 1834 and served 4 consecutive terms. During his time in the legislature, Lincoln championed causes such as infrastructure development, education, and economic growth. Lincoln studied law and became a licensed attorney in 1836. He moved to Springfield, Illinois, where he established a successful law practice. His legal career flourished, and he gained a reputation for his analytical skills, honesty, and ability to persuade juries. As Lincoln's reputation grew, so did his political aspirations. He joined the newly formed Whig Party and actively participated in political campaigns and debates. In 1846, he won election to the U.S. House of Representatives, representing Illinois' 7th Congressional District. Lincoln served 1 term in Congress, where he opposed the Mexican-American War and criticized President James K. Polk's policies. After his term in Congress, Lincoln returned to his legal practice, primarily focusing on his law career for the next few years. However, he remained engaged in political discussions and issues of national importance, particularly regarding slavery, which was becoming an increasingly contentious issue in the United States. In 1858, Lincoln ran as the Republican Party candidate for the U.S. Senate from Illinois, challenging the incumbent, Stephen A. Douglas, in a series of renowned debates. Although Lincoln lost the Senate race, the debates raised his national profile and established him as a formidable political figure. In 1860, Lincoln won the Republican Party's presidential nomination. He went on to win the presidential election, becoming the 16th president of the United States. His victory led to the secession of several southern states, which ultimately led to the American Civil War. Abraham Lincoln's childhood shaped his character, resilience, and commitment to education and self-improvement. His early political career laid the foundation for his eventual rise to the presidency, where he faced the significant challenges of leading a divided nation through a civil war and ultimately emancipating enslaved individuals through the Emancipation Proclamation. His legacy as a leader and his dedication to preserving the Union and abolishing slavery continue to be celebrated and studied today. If I had one word to describe ChatGPT's response, it would have to be plausible. I'm no Abraham Lincoln scholar, but to me, everything in that response seems plausible, in that it could be true. President's Day is celebrated in February, so it certainly makes sense that Lincoln's birthday is on February 12th, and 1809 seems about right in terms of the year. Could he have been born in 1810 and not 1809? Absolutely. So you just don't know if this is accurate. I did check his birthday with other sources, and it, in fact, was February 12th, 1809. But my point is that you might not take the time to check that fact because February 12th, 1809 seems plausible. That is the temptation of content created by ChatGPT. It's presented to you in a format that is well written, with no obvious red flags, and the substance of what you are being provided seems plausible. So plausible that you might be tempted not to check it, but you must. That is the trap Mr. Schwartz fell into. ChatGPT showed him excerpts from cases that looked like cases. Each case had party names, a docket number, a reporter citation, and text that purported to be the opinion of the court, but they were fake. These cases looked plausible, so Mr. Schwartz didn't check them. That mistake led to sanctions. Now, if ChatGPT had included a sentence that Abraham Lincoln traveled between campaign stops in an electric car, you'd know immediately that that couldn't possibly be true. But in my experience, ChatGPT rarely throws up those kind of red flags, unless you're talking about a subject where you are an expert yourself and could spot any mistake, no matter how small, that nearly everyone else would miss, which is why it is so tempting to trust what it is telling you. The next time ChatGPT presents you with some slick content that seems to nail the answer to whatever question you asked it, remember those summer associate memos of law and act accordingly. Now, does generative AI have the potential to change the practice of law? Absolutely. Andrew Perlman, who is the dean and a law professor at Suffolk University Law School, recently wrote an insightful article on this topic. I have included the cite to Dean Perlman's article in the written materials, and I highly recommend that you read it. It's an eye-opening article about generative AI from a prominent member of legal academia. I think Dean Perlman put it very well when he said, quote, "For the legal industry, ChatGPT may portend an even more momentous shift than the advent of the internet. A significant part of lawyers' work takes the form of written words in emails, memos, motions, briefs, complaints, discovery requests and responses, transactional documents of all kinds, and so forth. Although existing technology has made the generation of these words easier in some respects, such as by allowing us to use templates and automated document assembly tools, these tools have changed most lawyers' work in relatively modest ways. In contrast, AI tools like ChatGPT hold the promise of altering how we generate a much wider range of legal documents and information. In fact, within a few months of ChatGPT's release, law firms and legal tech companies are already announcing new ways of using generative AI tools." End quote. There are at least 4 areas where ChatGPT is expected to help lawyers do our jobs. Number 1, legal research. ChatGPT can be used to research legal topics quickly and easily. It can be used to find relevant case law, statutes, and regulations. It can also be used to summarize complex legal concepts. Number 2, legal document generation. ChatGPT can be used to draft legal documents, such as contracts, wills, and pleadings. It can be used to generate boilerplate language and to customize documents to the specific needs of a client. Number 3, legal analysis. ChatGPT can be used to analyze case law and to identify potential legal arguments. It can be used to identify the strengths and weaknesses of a case and to develop strategies for winning a case. Number 4, legal information. ChatGPT could be used to provide general legal information to the public, such as answering frequently asked questions or providing basic legal advice. Rather than me telling you about how ChatGPT can help lawyers with legal research, and this is how Mr. Schwartz chose to use ChatGPT and the reason we have the ChatGPT case to talk about here today, I'll take another page out of Dean Perlman's excellent article and ask you to see for yourself. While you're viewing this program, do a Google search for ChatGPT, Bard, or Bing Chat, which is Microsoft's generative AI chatbot. Log in or create a free account, and then run some queries for yourself. When you do this for the first time, you'll be presented with several very important disclaimers, and we'll talk about them in detail later. For now, just click through and let's get some hands-on experience with ChatGPT. For legal research, prompt ChatGPT to, quote, explain the concept of personal jurisdiction, end quote, or ask it to, quote, draft a brief to the U.S. Supreme Court on why its decision on same-sex marriage should not be overturned, end quote, and see what you get. I think you'll be very surprised and impressed by the quality of the responses. This is where you need to remember the summer associate memo and my new favorite word, plausible, because that is exactly what ChatGPT will be outputting to you. Dean Perlman, after summarizing the overall quality of Bing Chat's legal analysis as mimicking the level of a B+ law student, he was quick to add, quote, "To be clear, the responses generated by ChatGPT were imperfect and at times problematic. For example, the legal documents are incomplete, and its discussion of certain topics, like personal jurisdiction, lacked nuance," end quote. This is why I think my summer associate legal memo analogy is spot on. It's like the work of a B+ law student in terms of level of experience and knowledge, and it should be treated accordingly. I wonder how many summer associates these days are going to be using ChatGPT to prepare their legal memos. It certainly would save them some time and allow them to get to their fancy lunches and summer associate events that much earlier. Having now gone a couple of rounds with ChatGPT yourself, I want to point out a few things to you that you might now begin to appreciate. As AI expert Lance Elliott put it in an excellent article, also cited in the written materials, and I would urge you to read it. Quote, "Generative AI apps are exceedingly easy to use. All you need to do is enter a prompt, and the AI app will generate for you an essay that attempts to respond to your prompt. The composed text will seem as though the essay was written by the human hand and mind. Your first thought might be that this generative capability does not seem like such a big deal in terms of producing essays. You can easily do an online search of the internet and readily find tons and tons of essays on any topic. The kicker in the case of generative AI is that the generated essay is relatively unique and provides an original composition rather than a copycat. If you were to try and find the AI-produced essay online someplace, you would be unlikely to discover it. Generative AI is pre-trained and makes use of a complex mathematical and computational formulation that has been set up by examining patterns in written words and stories across the web. As a result of examining thousands and millions of written passages, the AI can spew out new essays and stories that are a mismatch of what was found. By adding in various probabilistic functionality, the resulting text is pretty much unique in comparison to what has been used in the training set." End quote. This is how the output of ChatGPT differs from what a standard Google search would return. It's an original composition, not a copy of something that someone else previously had written. That's a huge difference, and part of what makes ChatGPT so exciting. The flip side of not copying verbatim prior content is that ChatGPT makes it very difficult to determine when someone is using it to generate content. Think about the college student who turns in an essay that he purchased online. Or maybe he wrote the essay himself, but he copied and pasted large sections of it from materials that he found online. Lance Elliott again describes how ChatGPT already has changed the game. Quote, "That's why there has been an uproar about students being able to cheat when writing essays outside of the classroom. A teacher cannot merely take the essay that deceitful students assert is their own writing and seek to find out whether it was copied from some other online source. Overall, there won't be any definitive pre-existing essay online that fits the AI-generated essay. All told, the teacher will have to begrudgingly accept that the student wrote the essay as an original piece of work." End quote. The same is true for lawyers who use ChatGPT to write their briefs, law students to write their take-home exams, and law clerks to draft judicial opinions. It will be very difficult to prove that any of them use ChatGPT to create their, quote, original work, end quote. Now, you'll have examples like the lawyer in the ChatGPT Sanctions case that cited 6 cases that in fact did not exist. And he was caught when the opposing party pointed this out to the judge, who tore into the lawyer, as we'll see shortly. Ironically, if the judge's law clerks had used ChatGPT to draft the opinion in that case, might they have found the same 6 fake cases? How funny, but actually how scary, would that have been? But I digress. The point is that ChatGPT generates original content that will be hard for others to identify as the output of ChatGPT because it is original and not an exact copy of anything that came before it. The final observation also comes from Lance Elliott. Quote, "The allure of these generative AI apps is quite magnetic once you start using one. Step by step, you find yourself mesmerized and opting to put your toes further and further into the generative AI waters. The next thing you know, you are readily handing over proprietary content that is supposed to be kept private and confidential into a generative AI app. Resist the urge and please refrain from stepwise falling into an unsavory trap." End quote. Now that you've seen how easy it is to ask ChatGPT to write you an essay on any topic, legal or otherwise, you might be tempted to go back to the well time and time again. Maybe you're even tempted to try to improve the essay by giving ChatGPT feedback, look more into this, or don't bother including that, like you would if you were interacting with a summer associate or junior lawyer to whom you'd assign the task of writing the essay or legal memo. That is a slippery slope, not only because you get invested in what ChatGPT is creating, which very likely could be wrong, but you're now sharing more content with ChatGPT in your prompts. You might be including relevant facts that you learn from client confidential communications, for example. You might be applying your own legal or strategic insight to the problem in an effort to steer ChatGPT in the right direction. Although it is beyond the scope of today's presentation, and this was not an issue in the ChatGPT lawyer's case because Mr. Schwartz didn't disclose any client confidential information to ChatGPT, providing information to ChatGPT discloses it to the world. So that goes for client confidences, as well as your own legal insights and strategy, where it can be accessed and used by others. This is the, quote, unsavory trap, end quote, Lance Elliott is referencing. And for lawyers, that trap includes the serious risk of legal ethics violations. There are at least 8 areas of concern for practicing lawyers that relate to your ethical obligations to, number 1, be competent, number 2, maintain client confidences, number 3, protect client property and data, number 4, be candid before the court, number 5, not bring frivolous claims, number 6, supervise non-lawyer staff, number 7, avoid the unauthorized practice of law, and number 8, not discriminate against others on the basis of protected characteristics. I'm only going to discuss one of these 8 legal ethics issues in today's presentation because it is the one that is most applicable to the ChatGPT lawyer's case. However, I am going to discuss 3 other legal ethics issues that arise specifically from the actions of the lawyers in the ChatGPT case. If you're interested in hearing more about legal issues and ethics issues raised by generative AI, I would commend the other program I did recently in this area to you. With that background under our belts, let's turn back to the ChatGPT lawyer's case. I'm going to quote liberally from Judge Castle's opinion and order on sanctions, both because it describes the key facts of the case in detail and because it is a compelling read. I've included a copy of the opinion and order in the written materials, and I suggest you give the full opinion a read, as it does appear to be a case of first impression. As they say, let's begin at the beginning. Plaintiff Roberto Mata commenced a lawsuit in February 2022 by filing a complaint in the Supreme Court of the State of New York, New York County, asserting that he was injured when a metal serving cart struck his left knee during a flight from El Salvador to John F. Kennedy Airport. Defendant Avianca removed the action to federal court, asserting federal question jurisdiction under a treaty that governs certain aspects of international air travel known as the Montreal Convention. Stephen Allen Schwartz of Lebedow, and Oberman, PC, had been the attorney listed on the state court complaint, but upon removal from state court to the U.S. District Court for the Southern District of New York, Peter Loduca of the Lebedow firm filed a notice of appearance on behalf of Mr. Mata. Mr. Schwartz was not admitted to practice in the Southern District, and Mr. Loduca subsequently explained that because Mr. Schwartz was not admitted, Mr. Loduca filed the notice of appearance while Mr. Schwartz continued to perform all substantive legal work. In January 2023, Avianca filed a motion to dismiss on the grounds that Mr. Mata's claims were time-barred under the Montreal Convention. In March 2023, Mr. Loduca signed and filed an affirmation in opposition to the motion to dismiss, but he was not its author. Rather, the brief was researched and written exclusively by Mr. Schwartz. Recall that Mr. Schwartz was not admitted to practice in the federal court, so anything that needed to be filed in the case had to be done by Mr. Loduca and not Mr. Schwartz. So, this is where things start to get interesting. Once the issue of the fake cases came to light, and following a hearing Judge Castell had on his order to show cause why Messrs. Schwartz and Loduca should not be sanctioned, Mr. Schwartz submitted papers to the court stating that, quote, "My practice has always been exclusively in state court," end quote, and that he had attempted, quote, "to research a federal bankruptcy issue with which he was completely unfamiliar," end quote, in order to respond to Avianca's motion to dismiss. Okay, so you're a lifelong state court practitioner, and suddenly you find yourself in federal court facing a motion to dismiss, asserting grounds with which you are wholly unfamiliar. Not a comfortable place to be, but also not a completely foreign experience to any practicing litigator. You've brought claims on behalf of a client, and the defendant moves to dismiss based on a legal argument you've never faced before that you now need to research in order to determine how to respond. Clearly not an uncommon occurrence, but why on earth would any lawyer turn to ChatGPT to do that legal research? The answer in this case is perhaps understandable, but ultimately, Mr. Schwartz's decision to turn to ChatGPT was the first step on the path that led to his undoing. Here is an excerpt from Judge Castell's opinion on this point. Quote, "Mr. Schwartz has endeavored to explain why he turned to ChatGPT for legal research. The Lebedow firm primarily practices in New York state courts. It uses a legal research service called FastCase and does not maintain Westlaw or Lexis accounts. When Mr. Schwartz began to research the Montreal Convention, the firm's FastCase account had limited access to federal cases. According to Mr. Schwartz, and it had occurred to me that I heard about this new site, which I falsely assumed, was like a super search engine called ChatGPT, and that's what I used. Mr. Schwartz had not previously used ChatGPT and became aware of it through press reports and conversations with family members. Mr. Schwartz testified that he began by querying ChatGPT for broad legal guidance and then narrowed his questions to cases that supported the argument that the federal bankruptcy stay told the limitations period for a claim under the Montreal Convention. ChatGPT generated summaries or excerpts, but not full opinions, end quote. Before we get into the detail of what Mr. Schwartz asked ChatGPT and what responses ChatGPT provided, let's set the table in terms of our first legal ethics issue, which is the fundamental duty of competency. ABA Model Rule 1.1 provides, quote, "A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation," end quote. As this relates to Mr. Schwartz's decision to use ChatGPT for legal research, the main competency issue here is accuracy, or really the lack of accuracy, of the results that are being produced by ChatGPT. For any lawyer to behave the way Mr. Schwartz did here, i.e. to rely on the content being produced by ChatGPT in representing his client, you would need to be confident that ChatGPT produces accurate and reliable results. That is not the current state of things. Think about the summer associate legal memo analogy. You would violate ABA Model Rule 1.1, among others, if you relied on a legal memo written by a summer associate without independently verifying all of it. Another thing that bears mentioning is that most versions of ChatGPT only have data up through 2021. So anything that has happened since then, think the Supreme Court's decisions in the Dobbs case overturning Roe v. Wade or the Harvard case barring affirmative action in college admissions, would not be part of the dataset on which ChatGPT was trained and could not inform ChatGPT's answers to your prompts. That's a huge limitation. What if Westlaw had the same limitation? Would you feel confident in your legal research if Westlaw didn't include any cases decided after 2021? Beyond the gaps and the possibility of completely invented cases or other information, there is the very real problem that ChatGPT may not always be able to account for the nuances and complexities of the law. Because ChatGPT is a machine learning system, it does not have the same level of understanding and judgment as a human lawyer when it comes to interpreting legal principles and precedent. This could lead to problems in situations where a more in-depth legal analysis is required, which is most legal problems where significant amounts of money are at stake. Another good analogy is the difference between searching WebMD or some other website when you're feeling sick and you're trying to figure out what you might have versus going to see a doctor. If you're like me, you fully convinced yourself that you have a rare form of cancer by doom scrolling through medical sites online, only to be told by a doctor that all I needed was an antibiotic. While ChatGPT may be able to assist doctors and lawyers by assisting with daily tasks and improving efficiency, it can never be viewed as a replacement for the skills, judgment, and experience that doctors need to practice medicine and that lawyers need to practice law. While it's impressive that ChatGPT can match the success rate of the B+ law student, that's hardly the standard by which the competency of practicing lawyers is judged under ABA Model Rule 1.1. Nor would you want your cancer treated by a B+ medical student. I don't think there can be much debate that by relying solely on ChatGPT, a tool that he also failed to understand at even the most basic level, Mr. Schwartz violated his duty of competent representation under ABA Model Rule 1.1. Indeed, after just 1 hour of listening to this program, you already have an infinitely better understanding of ChatGPT and its limitations than Mr. Schwartz did at the time he submitted a brief to a federal court that cited opinions ChatGPT supplied him that turned out to be fake. It also bears reminding everyone that the problem of being a lawyer who is faced with a legal issue he or she doesn't fully understand is a common one. The common solution to that problem is to take the time to learn the issue yourself, if that is something you feel you can do, or to consult with other lawyers who are experts in that area to bring yourself up to speed. What literally no lawyer in history ever had done before Mr. Schwartz did it is to ask ChatGPT to teach him a legal issue and then file the results of ChatGPT's legal analysis with the court with no independent verification of any of that analysis. Interestingly, while this aspect of the duty of competence is straightforward, don't rely on a tool that isn't reliable, and you could fully satisfy that aspect of this duty by saying, I'm not going to go near this thing until it's 100% accurate. There is another aspect of the duty of competency that actually requires lawyers not to bury their heads in the sand and ignore ChatGPT entirely. Comment number 8 to ABA Model Rule 1.1 provides, quote, to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology, engage in continuing study and education, and comply with all continuing legal education requirements to which the lawyer is subject. End quote. Responsible lawyers don't ignore new technology, but rather, they study it carefully and only incorporate it into their legal practice once they are confident that they were taking the necessary precautions to minimizing the risks of the new technology. Mr. Schwartz, of course, he did the opposite. He jumped headfirst into the ChatGPT swimming pool, not knowing or bothering to find out if the water was deep enough. But let's imagine the other extreme, a lawyer who refuses to use email for client work. I think you could argue that any lawyer who doesn't use email for client work, at least in cases where it benefits the client, isn't fulfilling his or her duty to provide competent representation. Perhaps a better example is a lawyer who insists on verifying the accuracy of cases by shepherdizing them, using the actual books because he doesn't know how to use Westlaw or Lexis. I don't even know if they make the Shepherd's books anymore, but I think you see the point. A lawyer can't fulfill his or her duty of competency. That includes the duty to keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology, by ignoring new technologies like ChatGPT. If some commentators are right, and generative AI is going to be as important as electricity, lawyers will need to learn how to use it responsibly, just as we did when email, electronic legal research, e-filing, and every other innovation came along. ChatGPT is clearly not there yet, but we all have an ethical obligation to keep an eye on it, to make sure that if, when, and how it can be used in our practices consistent with our other ethical obligations, that we do so. Part of these changes will need to be driven by law schools, and to a lesser extent by CLE programs like this one, to educate the next generation of lawyers on these technologies, just as we learned about the newest technologies of the day when we were law students. I learned how to shepherdize cases using the books because online legal research was still relatively new at the time, but we learned both, and the latter quickly replaced the former. Once again, I think Dean Perlman nailed it on both points when he wrote, quote, law schools will face numerous related questions and challenges. In the short term, they will have to grapple with how to assess student performance on take-home exams and papers, now that students have easy access to AI tools. Looking further ahead, law schools will probably have to incorporate these tools into the curriculum in much the same way as they have taught students how to use electronic research tools. For example, first-year legal writing classes and clinical programs may need to teach AI document drafting so that future lawyers understand how to use the technology in practice. At my law school, Suffolk Law, we have demonstrated ChatGPT's capabilities to the faculty and have encouraged them to consider not just the threats from these tools, but the extent to which we should be actively teaching students how to use them. AI will not eliminate the need for lawyers, but it does portend the end of lawyering as we know it. Many clients, especially those facing complex issues, will still need lawyers to offer expertise, judgment, and counsel. But those lawyers will increasingly need AI tools to deliver those services efficiently and effectively. In fact, these tools are likely to become so valuable that lawyers may need them in certain contexts to satisfy their duty of competence, just as we would question the competence of a lawyer who shepherdizes citations using only books or prepares a legal document on a typewriter. In other words, clients will not want standalone lawyers who eschew AI. Conversely, clients with challenging legal matters are unlikely to rely on technology by itself. The future, at least for complex legal issues, will require the use of tech-enhanced lawyers, end quote. I don't think you can say it any better than that, so I'll leave it there. Now that you've had some experience yourself with ChatGPT, including asking it a few questions that require some legal research and analysis, I think it's useful to go through the queries Mr. Schwartz put to ChatGPT and the answers he received, all of which became part of the record in the order to show cause. Mr. Schwartz's first prompt stated, quote, "Argue that the statute of limitations is tolled by bankruptcy of defendant pursuant to Montreal Convention," end quote. ChatGPT responded with broad descriptions of the Montreal Convention, statutes of limitations, and the federal bankruptcy stay, advised that, quote, "The answer to this question depends on the laws of the country in which the lawsuit is filed," end quote, and then stated that the statute of limitations under the Montreal Convention is tolled by a bankruptcy filing. ChatGPT did not cite case law to support these statements. Mr. Schwartz then entered various prompts that caused ChatGPT to generate descriptions of fake cases, including, quote, "provide case law in support that statute of limitations is tolled by bankruptcy of defendant under Montreal Convention," end quote, quote, "show me specific holdings in federal cases where the statute of limitations was tolled due to bankruptcy of the airline," end quote, quote, "show me more cases," end quote, and, quote, "give me some cases where the Montreal Convention allowed tolling of the statute of limitations due to bankruptcy," end quote. When directed to provide specific case law and to show me specific holdings, the chatbot complied by making them up. At the time that he prepared the affirmation in opposition, Mr. Schwartz did not have the full text of any, quote, "decision" generated by ChatGPT. He cited and quoted only from excerpts generated by the chatbot. So that's what Mr. Schwartz did. Recall his earlier explanation to Judge Castell that he, quote, "falsely assumed," end quote, that ChatGPT was, quote, "like a super search engine," end quote, suggesting that it was reasonable for him to rely on the result, like you might rely on the results of a Google search to return web pages and information that actually exist, as opposed to creating them out of whole cloth. A mentor of mine, when I was a very young lawyer, was fond of saying, "Never assume a goddamn thing," and he was right. Interestingly, while the court faulted Mr. Schwartz for a great many things, and as the old saying goes, the cover-up often is worse than the crime, Judge Castile didn't specifically go after Mr. Schwartz for making the assumption that ChatGPT was a, quote, super search engine, end quote. This strikes me as odd, given the disclaimers one has to click through in order to access ChatGPT for the first time. I assume you saw those disclaimers when you tried it for yourself. The window that opens when you launch ChatGPT expressly states, quote, while we have safeguards in place, the system may occasionally generate incorrect or misleading information and produce offensive or biased content. It is not intended to give advice, end quote. On the ChatGPT homepage, under the section entitled Limitations, it states that ChatGPT, quote, may occasionally generate incorrect information, may occasionally produce harmful instructions or biased content, and limited knowledge of world and events after 2021, end quote. I'm guessing that Judge Castile was unaware that these disclaimers exist. Otherwise, I would have expected him to include among his findings that Mr. Schwartz's assumption that ChatGPT was, quote, like a super search engine, end quote, on which he could reasonably rely, was objectively unreasonable. Indeed, I believe that the existence of these disclaimers provides further proof that Mr. Schwartz violated his duty of competence under ABA Model Rule 1.1 by relying on information provided by ChatGPT without independently verifying it after having expressly been warned to not do so. At this point in the presentation, I'm curious if you're surprised by what you've learned about the case so far. Maybe you think it's crazy what this lawyer did and that he got off so easy, although, as I noted, the New York State Bar may not be finished with these lawyers. Maybe you think the poor guy made a stupid mistake and maybe didn't deserve to be sanctioned or to become famous as the new poster boy for bad lawyering. No matter what you think of this case at this point, I'm going to tell you something now that I am confident will surprise you. Mr. Schwartz could have done everything I've described so far. Used ChatGPT as his sole source of legal research and filed a brief with a federal court that cited 6 cases that were fake and did not exist, and he still would not have been sanctioned. Here is Judge Castile. Quote, the narrative leading to sanctions against respondents includes the filing of the March 1, 2023 submission that first cited the fake cases. But if the matter had ended with respondents coming clean about their actions shortly after they received the defendant's March 15th brief questioning the existence of the cases, or after they reviewed the court's orders of April 11th and 12th requiring production of the cases, the record now would look quite different. Instead, the individual respondents doubled down and did not begin to dribble out the truth until May 25th, after the court issued an order to show cause why one of the individual respondents ought not be sanctioned. For reasons explained and considering the conduct of each individual respondent separately, the court finds bad faith on the part of the individual respondents based upon acts of conscious avoidance and false and misleading statements to the court. Sanctions will therefore be imposed on the individual respondents, end quote. As I said, it's not the crime, it's the cover-up. Let's walk through how things began to unravel for Messrs. Schwartz and LaDuca. In March 2023, Avianca filed a 5-page reply memorandum to Mr. Schwartz's affirmation in opposition that included the following statement. Quote, although plaintiff ostensibly cites to a variety of cases in opposition to this motion, the undersigned has been unable to locate most of the case law cited in plaintiff's affirmation in opposition. and the few cases which the undersigned has been able to locate do not stand for the propositions for which they are cited." End quote. It impliedly asserted that certain cases cited in the affirmation in opposition were non-existent. Quote, "Plaintiff does not dispute that this action is governed by the Montreal Convention, and plaintiff has not cited any existing authority holding that the Bankruptcy Code tolls the 2-year limitations period, or that New York law supplies the relevant statute of limitations." End quote. It then detailed by name and citation 7 purported decisions that Avianca's counsel could not locate, and set them apart with quotation marks to distinguish a non-existent case from a real one, even if cited for a proposition for which it did not stand. Here's Judge Castile again. Quote, "Despite the serious nature of Avianca's allegations, no respondent sought to withdraw the March 1 affirmation or provide any explanation to the court of how it could possibly be that a case purportedly in the Federal Reporter or Federal Supplement could not be found. The court conducted its own search for the cited cases, but was unable to locate multiple authorities cited in the affirmation in opposition." End quote. As an aside, I was a law clerk for a U.S. District Judge in the Southern District of New York many years ago, and I can only imagine the conversations that went on in Judge Castile's chambers when his law clerks were trying to locate these fake cases. This case is really remarkable in so many ways, none of them good. This is a good point to start talking about Peter P. Loduca and the role he played in all of this. As I noted at the outset, the sanctions Judge Castile imposed were imposed jointly and severally on Mr. Loduca, Mr. Schwartz, and the Lebedeau firm. So it's clear that Mr. Loduca also engaged in conduct that the court sought fit to reprove. Mr. Loduca testified at the sanctions hearing that he received Avianca's reply submission and did not read it before he forwarded it to Mr. Schwartz. For his part, Mr. Schwartz did not alert Mr. Loduca to the contents of the reply. Clearly, Mr. Schwartz was driving the bus, and Mr. Loduca, a colleague who was associated with the same Lebedeau firm as Mr. Schwartz, was the attorney of record on the matter in name only. Does that mean Mr. Loduca wasn't responsible for the contents of the briefs and other documents filed with the court in his name? Of course not. Mr. Loduca is the one who signed the affirmation, and for the purposes of Rule 11 of the Federal Rules of Civil Procedure, as well as the court's inherent power to sanction attorneys, that is the first person who is on the hook if there is a problem. Beyond Rule 11, ABA Model Rule 5.1, entitled Responsibilities of a Partner or Supervisory Lawyer, provides as follows, quote, A partner in a law firm and a lawyer who individually or together with other lawyers possesses comparable managerial authority in a law firm shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that all lawyers in the firm conform to the rules of professional conduct. B, a lawyer having direct supervisory authority over another lawyer shall make reasonable efforts to ensure that the other lawyer conforms to the rules of professional conduct. C, a lawyer shall be responsible for another lawyer's violation of the rules of professional conduct if 1, the lawyer orders or, with knowledge of the specific conduct, ratifies the conduct involved, or 2, the lawyer is a partner or has comparable managerial authority in the law firm in which the other lawyer practices, or has direct supervisory authority over the other lawyer, and knows of the conduct at a time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action. End quote. While not a partner in the Levideau firm, Mr. LaDuca almost certainly would be held to be a lawyer who, quote, has direct supervisory authority over, end quote, Mr. Schwartz, at least as it related to the Mata versus Avianca litigation, in which Mr. LaDuca was signing the briefs and Mr. Schwartz was doing all of the work. Let's see how Mr. LaDuca did with regard to his general duty under ABA Model Rule 5.1 to, quote, make reasonable efforts to ensure that Mr. Schwartz conformed to the rules of professional conduct, end quote. The record revealed that Mr. LaDuca had reviewed the affirmation for style, stating, quote, I was basically looking for a flow, make sure there was nothing untoward or no large grammatical errors, end quote. Before executing the affirmation, Mr. LaDuca did not review any judicial authorities cited in his affirmation. There is no claim or evidence that he made any inquiry of Mr. Schwartz as to the nature and extent of his research or whether he had found contrary precedent. Mr. LaDuca simply relied on a belief that work produced by Mr. Schwartz, a colleague of more than 25 years, would be reliable. There was no claim made by any respondent in response to the court's orders to show cause that Mr. Schwartz had prior experience with the Montreal Convention or bankruptcy stays. I think you can make a strong case that by allowing a colleague with no federal court or bankruptcy experience submit a brief in your name, Mr. LaDuca did not fulfill his ethical obligations under ABA Model Rule 5.1 to, quote, make reasonable efforts to ensure that Mr. Schwartz conformed to the rules of professional conduct, end quote. In suggesting that Mr. LaDuca fell short here, it's worth remembering whom the legal ethics rules are, for the most part, intended to protect: our clients. While moving through the trees, we should not forget to step back and look at the forest. How do you think Mr. Mata feels about his lawyers sinking his personal injury case by filing a brief filled with fake cases? One of the sanctions Judge Castile imposed on Messrs. Schwartz and LaDuca was to send a copy of the court's order and the transcript of the hearing to their client, Mr. Mata, as if he somehow doubted that the lawyers would do this of their own accord, even though it's clearly a material development in this case. Is Mr. Mata likely to or capable of asserting a claim for malpractice? Maybe, or maybe not. But I think most clients wouldn't hesitate to raise a malpractice claim in such circumstances, at least as a defense to paying legal bills. There is the legal profession and the justice system that the legal ethics rules also serve to protect. But please don't forget how your conduct can affect your clients. Now, is that all Mr. LaDuca did that caused Judge Castile to sanction him? Once again, no. As with Mr. Schwartz, had Mr. LaDuca come clean immediately, he would not have been sanctioned. Unfortunately for Mr. LaDuca, once all of this came to light, Mr. LaDuca's role in the cover-up was exposed, which didn't sit well with Judge Castile. It started with some false statements in letters submitted to the court, albeit statements that in other contexts might be considered little white lies. After the court could not locate them, on April 11, 2023, the court issued an order directing Mr. LaDuca to file an affidavit by April 18, 2023, i.e. 1 week later, that annexed copies of the decisions cited in the affirmation in opposition. In response to the order, Mr. LaDuca sent a letter to the court requesting an extension of time to respond to April 25, 2023. The letter stated, quote, this extension is being requested as the undersigned is currently out of the office on vacation and will be returning April 18, 2023, end quote. Mr. LaDuca signed the letter and filed it with the court. Here is Judge Castile, after the hearing on the order to show cause, exposed the truth. Quote, Mr. LaDuca's statement was false, and he knew it to be false at the time he made the statement. Under questioning by the court at the sanctions hearing, Mr. LaDuca admitted that he was not out of the office on vacation. Mr. LaDuca testified that, quote, "My intent of the letter was because Mr. Schwartz was away, but I was aware of what was in the letter when I signed it. I just attempted to get Mr. Schwartz the additional time he needed because he was out of the office at the time," end quote. Is it okay to lie to a court about your vacation plans? Of course not. Judge Castle, quote, "The court finds that Mr. LaDuca made a knowingly false statement to the court that he was out of the office on vacation in a successful effort to induce the court to grant him an extension of time. The lie had the intended effect of concealing Mr. Schwartz's role in preparing the March 1 affirmation and the April 25 affidavit, and concealing Mr. LaDuca's lack of meaningful role in confirming the truth of the statements in his affidavit. This is evidence of the subjective bad faith of Mr. LaDuca," end quote. This is a good time to cover off ABA Model Rule 3.3, entitled Candor Toward the Tribunal, which states that, quote, A lawyer shall not knowingly, 1, make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. 2, fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. Or 3, offer evidence that the lawyer knows to be false. If a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. A lawyer may refuse to offer evidence other than the testimony of a defendant in a criminal matter that the lawyer reasonably believes is false, end quote. As you can see, there is no exception for little white lies about your vacation plans. Now, as Judge Castle observed, Mr. LaDuca wasn't telling a little white lie so that he could spend more time with his family during his vacation in Hawaii, but rather, he was actively trying to obscure the roles that he and Mr. Schwartz played in having submitted the fake cases as part of the cover-up. This is a good reminder not to include any false statements on any matter, however trivial you might deem it, in letters submitted to a court or when speaking in open court. If things go south, these statements will come back to haunt you, just as they did for Mr. LaDuca. Stepping back to see the forest, both Messrs. Schwartz and LaDuca violated ABA Model Rule 3.3a by citing fake cases, i.e. making, quote, false statements of law, end quote, to a court, and by failing to correct those false statements of law when it became clear that they were false. I would point out that the requirement that false statements of law must be made, quote, knowingly, end quote, in order to violate this rule does not save a lawyer like Mr. Schwartz, who blindly relied on ChatGPT, given all of the disclaimers that ChatGPT provides, as we have seen, nor does it save Mr. LaDuca, who did no checking of the citations before the affirmation was filed, or even after Avianca had filed a brief with the court strongly suggesting that the cases did not exist. Just as recklessness satisfies the intent requirement in many areas of civil and criminal law, I believe the New York State Bar could and should find that a reckless reliance on the results of a ChatGPT search to find case law support for an argument made to a court that the lawyer failed to verify would meet the standard of knowingly false statements of law under ABA Model Rule 3.3a. As we will see later, for purposes of imposing sanctions under Rule 11 and the court's inherent power, Judge Castle found that both Messrs. Schwartz and LaDuca acted in subjective bad faith, noting that a false statement of knowledge can constitute subjective bad faith where the speaker knew he had no such knowledge. More on that later. Unless and until such time, if ever, that ChatGPT or other generative AI tools can be found to give reliable answers to questions posed by lawyers, similar to how Westlaw or Lexis will return actual cases in response to your search results. The solve for this concern is not to use ChatGPT for legal research at all, or if you do, to independently verify any content that ChatGPT generates. Like a well-written summer associate legal memo, the temptation may be there to rely upon what you are being shown, but just like that legal memo, you simply can't unless you want to run the risk of a legal ethics violation, not to mention sanctions, and not to mention a very, very unhappy client. Our next stop on this slow-motion train wreck of a case is what Messrs. Schwartz and LaDuca decided to do once the court ordered them to provide copies of the fake cases. As I noted, coming fully 100% clean and throwing themselves on the mercy of the court would have saved them from being sanctioned, and also likely would have saved them from becoming media poster boys. The lesson here for young lawyers, but really all lawyers, as Messrs. Schwartz and LaDuca are in their 50s, is to own up to one's mistakes quickly, with the court, with clients, with more senior lawyers, to tell the truth, the whole truth, and nothing but the truth unprompted, and to accept the consequences. If you do that, you're more likely to come out of it unscathed, and for the incident to be viewed as a learning opportunity, than to be the recipient of a sanctions order that will follow you for the rest of your legal career. Rather than come clean, Messrs. Schwartz and LaDuca attempted to cover up the facts that Mr. Schwartz relied solely on ChatGPT to research his affirmation, and that Mr. LaDuca had done almost nothing in connection with the affirmation other than to sign his name to it. Apart from the legal ethics rules, these guys also failed to follow the first rule of holes, which is to stop digging. After making up the vacation excuse to give Mr. Schwartz more time to respond to the court's orders, Mr. LaDuca executed and filed an affidavit on April 25, 2023, that annexed what were purported to be copies or excerpts of all but one of the decisions required by the court's orders. Mr. LaDuca stated, quote, that I was unable to locate the case of Zickerman versus Korean Airlines, which was cited by the court in Varghese, end quote. The April 25th affidavit stated that the purported decisions it annexed, quote, may not be inclusive of the entire opinions, but only what is made available by online database, end quote. It did not identify any online database by name. It also stated, quote, that the opinion in Shaboon versus Egypt Air is an unpublished opinion, end quote. In fact, Mr. LaDuca did not author the April 25th affidavit, had no role in its preparation, and no knowledge of whether the statements therein were true. Mr. Schwartz was the attorney who drafted the April 25th affidavit and compiled its exhibits. Here's Judge Castell. Quote, at the sanctions hearing, Mr. Schwartz testified that he prepared Mr. LaDuca's affidavit, walked it into his office 20 feet away, and he looked it over and he signed it, end quote. There is no evidence that Mr. LaDuca asked a single question. Mr. LaDuca had not been provided with a draft of the affidavit before he signed it. Mr. LaDuca knew that Mr. Schwartz did not practice in federal court, and, in response to the order to show cause, he has never contended that Mr. Schwartz had experience with the Montreal Convention or bankruptcy stays. Indeed, at the sanctions hearing, Mr. Schwartz testified that he thought a citation in the form, quote, F. 3rd, end quote, meant, quote, Federal District, 3rd Department, end quote. This final line is pretty funny, particularly if you are a New York lawyer. While the New York State Appellate Division, which is the intermediate appeals court in New York, does in fact have departments, it strains credulity for any litigator who practices in New York to claim that he thought F3rd meant Federal District, 3rd Department, and not the third series of the Federal Reporter. This point was not lost on Judge Castle, who dropped the following footnote. Quote, "The court finds this claim from a lawyer who has practiced in the litigation area for approximately 30 years to be not credible, and was contradicted by his later testimony. The court, and F3rd is the 3rd edition of the Federal Reporter, correct? Mr. Schwartz, right," end quote. Because the April 25th affirmation only attached the excerpts that ChatGPT had provided to Mr. Schwartz, it did not comply with the court's orders because it did not attach the full text of any of the cases that are now admitted to be fake. For his part, Mr. LaDuca testified, quote, "Me, I didn't do anything other than turn over to Mr. Schwartz to locate the cases that the court had requested," end quote. He testified that he read the April 25th affidavit and, quote, "saw the cases that were attached to it. Mr. Schwartz had assured me that this was what he could find with respect to the cases, and I submitted it to the court," end quote. Mr. LaDuca had observed that the cases annexed to his April 25th affidavit were not being submitted in their entirety, and explained that, quote, "I understood that was the best that Mr. Schwartz could find at the time based on the search that he or the database that he had available to him," end quote. Mr. LaDuca testified that it, quote, "never crossed his mind," end quote, that the cases were bogus. On the one hand, the idea that ChatGPT or any other online platform would make up judicial decisions out of whole cloth is a wild idea, so you can understand where Mr. LaDuca is coming from. That said, he didn't even look at the excerpts of the cases to see if they seemed correct, even after a court had ordered them to be produced. What would Mr. LaDuca have discovered had he done so? Again, let's turn to Judge Castle's opinion, where he talks about what he found when he examined the fake case known as Varghese. Quote, "The court reviewed the purported decisions annexed to the April 25th affidavit, which have some traits that are superficially consistent with actual judicial decisions. The court need not describe every deficiency contained in the fake decisions annexed to the April 25th affidavit. It makes the following exemplar findings as to the 3 decisions that were purported to be issued by federal courts. The Varghese decision is presented as being issued by a panel of judges on the United States Court of Appeals for the 11th Circuit that consisted of Judges Adalberto Jordan, Robin S. Rosenbaum, and Patrick Higginbotham, with the decision authored by Judge Jordan. Judge Higginbotham is a senior judge of the United States Court of Appeals for the 5th Circuit, not the 11th Circuit. Judges Jordan and Rosenbaum sit on the 11th Circuit. It bears the docket number 18-13694. Varghese discusses the Montreal Convention's limitations period and the purported tolling effects of the automatic federal bankruptcy stay, 11 U.S.C. 362A. The clerk of the United States Court of Appeals for the 11th Circuit has confirmed that the decision is not an authentic ruling of the court and that no party by the name of Varghese has been a party to a proceeding in the court since the institution of its electronic case filing system in 2010. The Varghese decision shows stylistic and reasoning flaws that do not generally appear in decisions issued by United States Courts of Appeals. Its legal analysis is gibberish. It references a claim for the wrongful death of George Scaria Varghese brought by Susan Varghese. It then describes the claims of a plaintiff named Anish Varghese, who, due to airline overbooking, was denied boarding on a flight from Bangkok to New York that had a layover in Guangzhou, China. The summary of the case's procedural history is difficult to follow and borders on nonsensical, including an abrupt mention of arbitration and a reference to plaintiff's decision to file for Chapter 7 bankruptcy as a tactical response to the district court's dismissal of his complaint. Without explanation, Varghese later references the plaintiff's Chapter 13 bankruptcy proceeding. The Varghese defendant is also said to have filed for bankruptcy protection in China, also triggering a stay of proceedings. Quotation marks are often unpaired. The Varghese decision abruptly ends without a conclusion. The Varghese decision bears the docket number 18-13694, which is associated with the case George Cornea versus the U.S. Attorney General. The federal reporter citation for Varghese is associated with J.D. versus Azar, 925 F. 3rd, 1291, D.C. Circuit, 2019. Furthermore, the Varghese decision includes internal citations and quotes from decisions that are themselves non-existent. All I can say is, wow. And then I would add to that the word plausible. First of all, doesn't anyone check case citations anymore before filing briefs? When I was a young lawyer, we did this for every citation in every brief, just to make sure we didn't have any typos in the citations. Of course, we weren't worried about cases not existing, but a citation check would have uncovered that. Same thing with shepherdizing cases. We did that with every one to make sure they were still good law at the time we filed our brief. We did that same thing again right before oral argument on the motion, just to make sure they were still good law before we stood up to argue the motion. I still remember one case where we checked one of our opponent's citations the day before oral argument, and it turned out that that case, which was a very recent decision, had been reversed the day before. We also did the honorable thing and let our adversary know about the reversal rather than sandbag him in the oral argument, which is what we would call a professional courtesy. This is what good lawyers do. So please be a good lawyer and check your citations. That's the wow part of this. The plausible part is to recall what I said about ChatGPT providing responses that seem plausible. That's exactly what it did here. It made up cases and made them look plausible. Each case had party names, a docket number, a reporter citation, a court name, the judges' names who purportedly heard the case, and at least some text that purported to be the opinion of the court, including internal case citations, many of which themselves had been made up. Messrs. Schwartz and LaDuca should have independently verified these cases, but they didn't because they looked plausible. To use my analogy, they took the summer associate memo and they filed it with the court. Apart from being mistaken on the law, as any summer associate could be, this particular summer associate made up fake cases, so it made it far worse for these lawyers than they thought it could possibly be, and that's one of the reasons that they were sanctioned. The other reason they were sanctioned is that instead of coming clean, even after the fake cases came to light, Mr. Schwartz continued to attempt to minimize his culpability by making more false and misleading statements to the court. As noted, each of these false statements violates ABA Model Rule 3.3a. In his affidavit, filed on May 25th, Mr. Schwartz stated that he relied on ChatGPT, quote, to supplement the legal research performed, end quote. He also stated that he, quote, greatly regrets having utilized generative artificial intelligence to supplement the legal research performed herein, end quote. But at the hearing, Mr. Schwartz acknowledged that ChatGPT was not used to, quote, supplement his research. The court: let me ask you, did you do any other research in opposition to the motion to dismiss other than through ChatGPT? Mr. Schwartz: other than initially going to Fastcase and failing there, no. The court: you found nothing on Fastcase. Mr. Schwartz: Fastcase was insufficient as to being able to access, so no, I did not. The court: you did not find anything on Fastcase. Mr. Schwartz: no. The court: in your declaration in response to the order to show cause, didn't you tell me that you used ChatGPT to supplement your research? Mr. Schwartz: yes. The court: well, what research was it supplementing? Mr. Schwartz: well, I had gone to Fastcase, and I was able to authenticate 2 of the cases through Fastcase that ChatGPT had given me. That was it. The court: but ChatGPT was not supplementing your research. It was your research, correct? Mr. Schwartz: correct. It became my last resort, so I guess that's correct. As you probably expect by now, Judge Castile really didn't love that part. Quote, Mr. Schwartz's statement in his May 25 affidavit that ChatGPT, quote, supplemented, end quote, his research was a misleading attempt to mitigate his actions by creating the false impression that he had done other meaningful research on the issue and did not rely exclusively on an AI chatbot, when in truth and in fact, it was the only source of his substantive arguments. These misleading statements support the court's finding of subjective bad faith, end quote. I won't go into any more detail, but the court also found that Mr. Schwartz gave other inconsistent and misleading explanations for his conduct, what he was thinking, what doubts he had about ChatGPT, etc., that the court later cited as further support for his finding that Mr. Schwartz acted in subjective bad faith and thus deserved to be sanctioned under Rule 11. As for Mr. Loduca, Judge Castile found that he acted in subjective bad faith that warranted sanctions because, quote, A, Mr. Loduca violated Rule 11 in not reading a single case cited in his March 1 affirmation in opposition and taking no other steps on his own to check whether any aspect of the assertions of law were warranted by existing law. An inadequate or inattentive inquiry may be unreasonable under the circumstances, but signing and filing that affirmation after making no inquiry was an act of subjective bad faith. This is especially so because he knew of Mr. Schwartz's lack of familiarity with federal law, the Montreal Convention, and bankruptcy stays, and the limitations of research tools made available by the law firm with which he and Mr. Schwartz were associated. B, Mr. Loduca violated Rule 11 in swearing to the truth of the April 25 affidavit with no basis for doing so. While an inadequate inquiry may not suggest bad faith, the absence of any inquiry supports a finding of bad faith. Mr. Schwartz walked into his office, presented him with an affidavit that he had never seen in draft form, and Mr. Loduca read it and signed it under oath. A cursory review of his own affidavit would have revealed that, number 1, Zickerman versus Korean Airlines could not be found. Number 2, many of the cases were excerpts and not full cases. Number 3, reading only the opening passages of, for example, Varghese, would have revealed that it was internally inconsistent and nonsensical. C. Further, the court directed Mr. Loduca to submit the April 25 affidavit, and Mr. Loduca lied to the court when seeking an extension, claiming that he, Mr. Loduca, was going on vacation when, in truth and in fact, Mr. Schwartz, the true author of the April 25 affidavit, was the one going on vacation. This is evidence of Mr. Loduca's bad faith." End quote. Finally, the coup de grace was Judge Castle's finding that the Lebedeau firm was jointly and severally liable under Rule 11 for the conduct of Messrs. Schwartz and Loduca. The court, quote, "Rule 11(c)(1) provides that, absent exceptional circumstances, a law firm must be held jointly responsible for a violation committed by its partner, associate, or employee." End quote. The Lebedeau firm has not pointed to exceptional circumstances that warrant a departure from Rule 11(c)(1). Mr. Corvino, the sole equity partner of the Lebedeau firm, has acknowledged responsibility, identified remedial measures taken by the Lebedeau firm, including an expanded fast case subscription and CLE programming, and expressed his regret for respondents' submissions. End quote. Separate from sanctions under Rule 11, as we saw before, both Mr. Corvino and Mr. Loduca could be held liable for Mr. Schwartz's violations of the legal ethics rules pursuant to ABA Model Rule 5.1, which specifies the responsibilities of a partner or supervisory lawyer. If you practice in a law firm, this is an additional reason why you need to be extremely careful how you behave in connection with your representation of clients on behalf of your firm. Although I won't discuss it here, you also should be mindful of ABA Model Rule 5.3, which is entitled Responsibilities Regarding Non-Lawyer Assistants, which states that, quote, "With respect to a non-lawyer employed or retained by or associated with a lawyer, a partner and a lawyer who individually or together with other lawyers possesses comparable managerial authority in a law firm, shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that the person's conduct is compatible with the professional obligations of the lawyer. B, a lawyer having direct supervisory authority over the non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. And C, a lawyer shall be responsible for conduct of such a person that would be a violation of the rules of professional conduct if engaged in by a lawyer if 1. The lawyer orders or, with the knowledge of the specific conduct, ratifies the conduct involved, or 2. The lawyer is a partner or has comparable managerial authority in the law firm in which the person is employed, or has direct supervisory authority over the person and knows of the conduct at a time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action. In addition, in August 2019, the ABA House of Delegates passed Resolution Number 112 that provided, quote, "Resolved that the American Bar Association urges courts and lawyers to address the emerging ethical and legal issues related to the usage of artificial intelligence, AI, in the practice of law, including 1. Bias, explainability, and transparency of automated decisions made by AI, 2. Ethical and beneficial usage of AI, and 3. Controls and oversight of AI and the vendors that provide AI." End quote. Some commentators have pointed out that non-lawyer assistance in ABA Model Rule 5.3 includes non-human assistance of the sort that ChatGPT provides. The ABA resolution is very clear when it counsels lawyers specifically to make sure there are controls and oversight of AI and the vendors that provide AI, such as ChatGPT. Just like when lawyers delegate tasks to paralegals, law students, or vendors, ABA Model Rule 5.3 requires the lawyer to ensure that he or she has measures in effect to give reasonable assurance that the person's conduct upholds the lawyer's professional obligations. If you give client documents to a vendor for analysis, you need to have an agreement in place with the vendor that requires the vendor to keep those documents confidential. If you ask a paralegal to research a factual issue, you need to make sure that his or her work is adequately supervised and reviewed. If you ask a law student to write a legal memo, you need to independently verify the legal analysis and conclusions contained in that memo. As we've seen, ChatGPT offers no way to audit the process by which it does research when you ask it a question, and no confidence that its legal research and/or legal analysis is valid or even based on actual laws and cases. Accordingly, any lawyer who relies on ChatGPT to assist him or her in the practice of law risks also violating ABA Model Rule 5.3. Now, this is a legal ethics program, and Rule 11 of the Federal Rules of Civil Procedure obviously is not an ethics rule. Rule 11 also only applies to litigators and not transactional lawyers. That said, ethical violations often result in the imposition of sanctions under Rule 11 and vice versa. Plus, in terms of providing full coverage of what happened in the ChatGPT lawyer's case, we really need to spend a few minutes talking about Rule 11 because that was the primary basis upon which Judge Castle based his sanctions order. Rule 11b2 states, quote, "By presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or unrepresented party certifies that to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, the claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law, or for establishing new law," end quote. Quote, "Under Rule 11, a court may sanction an attorney for, among other things, misrepresenting facts or making frivolous legal arguments," end quote. Muhammad versus Walmart Stores East LP, 732 F. 3rd 104, 2nd Circuit 2013 per curiam. A legal argument may be sanctioned as frivolous when it amounts to an, quote, "abuse of the adversary system," end quote. Salavera versus Eckhart, 222 F. 3rd 19, 2nd Circuit 2000, quoting Moreno versus Rowe, 910 F. 2nd, 1043, 2nd Circuit 1990. Quote, "Merely incorrect legal statements are not sanctionable under Rule 11b2, end quote. Story versus Cello Holdings, LLC, 347 F. 3rd 370, 2nd Circuit 2003. Quote, "The fact that a legal theory is a long shot does not necessarily mean it is sanctionable," end quote. Fishoff versus Cody Inc., 634 F. 3rd 647, 2nd Circuit 2011. A legal contention is frivolous because it has, quote, "no chance of success," end quote, and there is, quote, "no reasonable argument to extend, modify, or reverse the law as it stands," end quote. That's from the same case. An attorney violates Rule 11b2 if existing case law unambiguously forecloses a legal argument. See Starmark Management, Inc. versus Kun Chung Hing Key Soy Sauce Factory, 682 F. 3rd 170, 2nd Circuit 2012, affirming Rule 11b2 sanction for frivolous claims where plaintiffs' trademark claims, quote, "clearly lacked foundation," end quote, per curiam. Also citing Simon DiBartolo Group, LP versus Richard E. Jacobs Group, Inc., 186 F. 3rd 157, 2nd Circuit 1999, affirming Rule 11b2 sanction where no authority supported plaintiff's theory of liability under SEC Rule 10b13. The filing of papers, quote, "without taking the necessary care in their preparation," end quote, is, quote, "an abuse of the judicial system," end quote, that is subject to Rule 11 sanction. Cooter and Gell versus Hartmax Corp., 496 U.S. 384, 1990. Rule 11 creates an, quote, "incentive to stop think and investigate more carefully before serving and filing papers, quote, from the same case. Quote, Rule 11 explicitly and unambiguously imposes an affirmative duty on each attorney to conduct a reasonable inquiry into the viability of a pleading before it is signed, end quote. AJ Energy LLC versus Worry Bank, 829 Federal Appeals, 533, 2nd Circuit 2020. Summary order. Quoting Gutierrez versus Fox, 141 F. 3rd, 425, 2nd Circuit, 1998. While the ChatGPT case presented an issue of first impression, I think it's obvious from this description of relevant Rule 11 case law that what Messrs. Schwartz and LaDuca did here constituted clear violations of that rule. Once a Rule 11 violation is found, the question is whether and what type of sanction the court should impose. A threshold for imposing any sanction is a finding of subjective bad faith. And, as I already noted, the court found that both Messrs. Schwartz and LaDuca had acted in subjective bad faith, so their goose was cooked on that important point. One defense they did raise in an effort to avoid the imposition of sanctions was to cite a case called Braun XREL Advanced Battery Technologies, Inc. versus Jingzhou Fu, 2015 Westlaw 438-9893, Southern District, New York, July 10, 2015, which declined to sanction a law firm associate who drafted and signed a complaint that falsely alleged that the plaintiff in a shareholder derivative suit was a shareholder of the nominal defendant. That attorney acted in reliance on the plaintiff's signed verification of the complaint, partner communications with the plaintiff, and contents of law firm files that appeared to contain false information. Braun concluded that this attorney did not act with subjective bad faith by innocently relying on the mistruths of others. There is no suggestion in Braun that this attorney had a reason to know or suspect that he was relying on falsehoods or misinformation. Judge Castile distinguished that case, which was a real case cited by these lawyers, couldn't resist taking at least one shot at them in passing, by observing that here, quote, respondents advocated for the fake cases and legal arguments contained in the affirmation in opposition after being informed by their adversary's submission that their citations were non-existent and could not be found. Mr. Schwartz understood that the court had not been able to locate the fake cases. Mr. LaDuca, the only attorney of record, consciously avoided learning the facts by neither reading the Avianca submission when received, nor after receiving the court's orders. Respondents' circumstances are not similar to those of the attorney in Braun, end quote. Before we leave the Rule 11 discussion, it's important to point out why the Lebedeau firm was part of the joint and several sanctions order. This answer is actually straightforward. Rule 11(c)(1) provides that, quote, absent exceptional circumstances, a law firm must be held jointly responsible for a violation committed by its partner, associate, or employee, end quote. The court found that, quote, the Lebedeau firm has not pointed to exceptional circumstances that warrant a departure from Rule 11(c)(1). Mr. Corvino has acknowledged responsibility, identified remedial measures taken by the Lebedeau firm, including an expanded fast case subscription and CLE programming, and expressed his regret for respondent submissions, end quote. So, you need to keep in mind that your individual conduct, if it merits sanctions being imposed on you, will also subject your law firm to sanctions under Rule 11, absent a showing of, quote, exceptional circumstances, end quote. So, what was the final sanctions order issued by Judge Castile? Quote, the court orders the following sanctions pursuant to Rule 11, or alternatively, its inherent authority. A, within 14 days of this order, respondents shall send via first-class mail a letter individually addressed to Plaintiff Roberto Mata that identifies and attaches this opinion and order, a transcript of the hearing of June 8, 2023, and a copy of the April 25 affirmation, including its exhibits. B. Within 14 days of this order, respondents shall send via first-class mail a letter individually addressed to each judge falsely identified as the author of the fake Varghese, Shaboon, Peterson, Martinez, Durden, and Miller opinions. The letter shall identify and attach this opinion and order, a transcript of the hearing of June 8, 2023, and a copy of the April 25 affirmation, including the fake, quote, opinion, end quote, attributed to the recipient judge. C. Within 14 days of this opinion and order, respondents shall file with this court copies of the letters sent in compliance with A and B. D. A penalty of $5,000 is jointly and severally imposed on respondents and shall be paid into the registry of this court within 14 days of this opinion and order. I think Judge Castile summed up the lessons of this case best when he wrote, quote, "In researching and drafting court submissions, good lawyers appropriately obtain assistance from junior lawyers, law students, contract lawyers, legal encyclopedias, and databases, such as Westlaw and Lexis. Technological advances are commonplace, and there is nothing inherently improper about using a reliable artificial intelligence tool for assistance. But existing rules impose a gatekeeping role on attorneys to ensure the accuracy of their filings. Peter Loduca, Stephen A. Schwartz, and the law firm of Lebedow, and Oberman, P.C., abandoned their responsibilities when they submitted non-existent judicial opinions with fake quotes and citations created by the artificial intelligence tool ChatGPT, then continued to stand by the fake opinions after judicial orders called their existence into question," end quote. As I said, a case of first impression and a phenomenal opinion that I highly recommend to you. It will serve as a reminder that you never want to be the subject of such an opinion, ever. I hope you enjoyed today's program. Thanks for joining me.